Good day and welcome to another episode of Maintenance Matters. Today we have Deon Ruiters. He is one of the senior maintenance prosecutors here in the Western Cape. Deon, welcome once again.
Hi, Eugene, and welcome to our listeners.
Deon, one of the questions that we have quite often on our groups, and that's now my group and Felicity's group on maintenance on Facebook, is the question of claiming maintenance from grandparents if the father of the child is not capable or able to pay maintenance. Can you please explain that to us a little bit more?
Sure. What usually happens is the last time when we spoke about the Section 6 informal inquiry that is held in the maintenance office with the maintenance officer and the two parents, that's the mother and the father. And during the Section 6 inquiry, it comes to light that the father cannot contribute the amount that is requested by the mother, the applicant, or he don't have any funds to contribute anything at all. Then the question that the maintenance officers should ask is whether his parents are alive. In a case where both or one of the grandparents are alive, then obviously they can be held accountable. But that you will not find in any piece of legislation. You don't find it in the Maintenance Act. There's no word about it in the Maintenance Act. The only place you will find it is in case law. And in the South African context, there are two cases dealing with it. The one is Jade Lee Peterson versus Magistrate Simonstown, and the other one is Hopis versus de Klerk. Both these matters dealt with how you can hold the grandparents liable for maintenance of their child who obviously now is in court for maintenance. The maintenance officer must first make a finding and take that finding to the court to tell the court that, Your Worship, I've done a Section 6 inquiry and this is the expenses of the child. The applicant is earning this amount and the respondent is earning X amount or is not earning any money or whatever the case might be. Therefore, the maintenance officer asked the court then to declare that the respondent do not have the means to comply with the order. Then the next hurdle is, are there any other relatives, or not any other relatives, any blood relation to the respondent and the applicant that can be held liable? And in terms of the Jade Lee Peterson versus Magistrate Simonstown case, it says that the parents from both sides, that is from the mother side as well as from the father side, can be held liable, but not the uncles or aunts or any other relative. So the uncles or aunts or any other relative except the grandparents, those are the only ones that can be held liable. Then the court will make a finding that the respondent do not have the sufficient means. Therefore, the court will then instruct or direct to the maintenance officer, Mr. Maintenance Officer or Miss Maintenance Officer, you can then in the specific case send out a Section 9(2) summons because it's already now in the court. Therefore, you can issue a Section 9(2) summons and then summons the grandparents from both sides, the mother side as well as the father side. Even in a case where the mother, that the applicant that made the case is living with the parents and the parents are already contributing, they still need to come and say, yes, we are already contributing and this is our contribution by providing a house to the applicant, by providing food or whatever the case might be. And then all of those things the maintenance officer will then take in consideration when they make a decision of how much the contribution from the respondent's parents should be in a case where the applicant's parents are already contributing. But all of that needs to be put on record before the court can make then a decision and put that decision on a J168. That is the court order form, and the court will do that in terms of Section 16 of the Maintenance Act to then issue that order. But it's important for our viewers and listeners to just note that both parents will be summoned, not just the applicant's parents, but both the respondent and applicant's parents. Both of them will be, a set of parents will then be summoned. In a case where there is a mother deceased from the grandmother or grandfather's deceased, then we will still continue with the one parent, one grandparent that's still alive. So if the applicant's mother passed away but the father is still there, then we will then also conduct that inquiry with the mother's father. And in a case where the respondent's father passed away but the mother, the grandmother on the father's side is available, then whoever is still alive are the ones that we will summon to court. And then we will deal with the case in front of the magistrate.
And the order against the grandparents are then a valid court order for paying maintenance as a substitute for the father that cannot pay maintenance. So what would be the event if the grandparents cannot afford at a later stage because they only get pension and they only can pay for 6 months, and then after 6 months they go on pension and they do not have an income? What would be the procedure then? What is the legal situation regarding that?
In such a case where the court made an order in terms of Section 16 and ordered a J168 court order, and at some stage the grandparents can't afford the order that was made against them, then they can approach the court in terms of Section 6 to ask that that order be amended or reduced or discharged. Any of those things can happen. So the order can be reduced, it can be amended, or it can then, in that specific case, also be discharged, where the parents will say that the grandparents will say there was a change in their financial circumstances, and because of the change in financial circumstances, they can't afford the order that was made in terms of Section 16 on a J168. Therefore, they ask the court to please reduce the amount or to completely discharge the order against them. The court will then listen to the party bringing the application for a reduction or amendment or discharge, and the party will have to show what we call good cause. They must give reasons why it should be reduced or be amended. It's not just automatic that once they submit the form, then it is now that it is reduced or that it is amended or discharged. The court must first give an order and say, okay, I've heard your evidence, therefore I feel that the order must be reduced, therefore I feel the order must be amended, therefore I feel the order must be discharged. But all of those decisions will be made by the court once they have all that information in front of the magistrate. If it is not, all that information is not there, then obviously the court will first need to, the maintenance officer will first need to investigate and get all of that investigations and present all of that in front of the magistrate.
Okay, another question that we have is, can someone be jailed? Can someone be put in jail for not paying maintenance?
Yes, there are case law in the Western Cape that says specifically that in a case where a person do not comply with the maintenance order, there's nothing in law that says that the first offender can't be jailed and be given a custodial sentence and be imprisoned. The case is State versus Gideon Visser. In the case of Mr. Gideon Visser, it was decided that the mere fact that he's working, because most respondents, whenever they get to court, then they will all of a sudden say that no, but they've got employment, and then if you're going to, Mr. Magistrate, Mr. Court, if you send me to court, to jail, then who's going to then pay for maintenance, or who's then going to take care of my children, because then they all of a sudden want to take care of their children. So what the court said in that specific case is, well, in that case, then we will let you work during the week. So since you now all of a sudden have this great desire now to take care of your child, so let's take care of the child. But over weekends, there's nothing that says that you can't get a custodial sentence where you serve periodic sentence at a specific correctional facility. So a first offender can be sent to jail. State versus Gideon Visser is clear on it. So the perception that they will just get a suspended sentence and be given another chance, that's not completely true. And there are also other means that we can hold the defaulting respondent liable for whatever non-compliance or defaulting action he had during that period.
Another thing that is quite confusing for a lot of people and for a lot of listeners is that in maintenance matters, we deal with a civil procedure on the one side, and then we deal with a criminal procedure on the other side. A lot of the people don't understand that these are two completely separate issues. The maintenance court might not hear the criminal matter and the other way around. So it might be two different magistrates responsible for one doing the civil procedure in terms of the maintenance inquiries, and then for the criminal one. Can you just explain a little bit more regarding that, just to clarify
Okay.
that?
Sure. So whenever the applicant comes to the maintenance court, that first process is part of civil process until a court order is made in terms of Section 16 on a J168. So once that has been done and there's defaulting action, then he will be moved to when he committed a default in his actions and didn't comply with the order, then the court can do one of two things. They can, in terms of Section 26, then do a civil attachment and then either attach his emoluments, which is his salary or whatever the case might be, or it can attach his assets like a car or his furniture or whatever the case might be, or it can be an attachment of debt, which is in a case where he's got a retirement annuity or pension fund or any of those things, then that can also be attached once it's due and payable to him. Then those are the recourses. So when the lady complains on a J470 complaint form to the maintenance officer that there was a default in action, that he didn't comply with the order, then the uh, lady will have one of two recourses, either civil or criminal. Civil, where you, in terms of Section 26, do the civil attachment of emoluments, of assets, or of debt, that is retirement annuities or pension funds or whatever the case might be, or else in terms of Section 31, you can have the prosecution of the matter in a criminal court. The other misconception is once you do the one, you can't do the other. That's not true. You can have a case where you, in the civil court, do the attachment for emoluments, but because of his past conduct of not complying with it, there's nothing that says that it can't be dealt with in the criminal court at the same time while it's in the civil court. But in most cases, the courts do not work like that because it's one maintenance file and it's usually being split between the civil court and the criminal court. So if it's on one day, then who's going to be dealing with the file first? So to avoid any of those type of things happening, we in the justice system will first finish the civil section and attach, and then if the applicant still feels that she wants to pursue a criminal prosecution, then we can still prosecute on that same set of facts for past misconduct where he didn't comply with the order. But there's nothing that says, there's no point in law that says that once you do the civil attachment, that you can't also do the criminal prosecution. If the applicant feels strongly about a case, you can also ask, while she's attaching his emoluments, that it still continue in the criminal court.
Wouldn't it be considered a conflict of interest if the same magistrate hears the criminal matter and the maintenance matter?
Well, in some courts, they do see it as a conflict of interest dealing with the same magistrate. But in criminal cases, we need to show beyond a reasonable doubt. So those facts needs to be adduced by the prosecutor in order to convince the court beyond a reasonable doubt that the person is guilty. So if it is a one-man station where there's only one magistrate, especially in the rural areas where we don't have so many magistrates as in the metro areas that will be able to listen to both the civil as well as the criminal side of matters. In metro areas, we can always give it to a civil magistrate and then to a criminal magistrate. But in a one-man station, in small places like Claver or of Maritzburg or any of the other centers that only have one magistrate, the facts that will be presented in front of the magistrate in civil is beyond is a balance of probabilities, while in criminal cases it's beyond a reasonable doubt. But the magistrate in most cases in the civil court do not hear the applicant or any of that. All of it is documentary evidence. In the civil court, they only work with the J470, the J306, and then an affidavit by the maintenance officer or by the applicant in which he says that the order was not complied with, therefore she asked for enforcement of the order and she wants emoluments, and it's all documented evidence. So it's not as if there is a physical being standing in front of a magistrate in the civil court. It is all documentary evidence that is being dealt with over there. So in that sense, I do not feel that a magistrate will be influenced because they deal with so many of these cases per day where documentary evidence is being submitted without them seeing the applicant. I don't see any reason why that same magistrate that sat in the civil court dealing with documentary evidence cannot hear the case in the criminal court where the applicant will actually come and have to physically testify in court, which is a different set of rules and a different set of criteria to find the person to be held liable. While in the case of a civil case, it will be done on a balance of probabilities. In criminal cases, beyond a reasonable doubt. So balance of probabilities, documentary evidence, a criminal case that is dealt with a viva voce evidence, oral evidence of the applicant in court. So I don't see anything wrong with it, but I know some courts all over South Africa will feel that there might be conflict of interest and therefore different magistrate. I'm not completely convinced with that argument.
That was Advocate Deon Ruiters, Senior Prosecutor in Maintenance of the Western Cape. Deon, thank you so much, and we look forward to seeing you again. Thank you so much.
Thank you, Eugene.
Bye-bye.
Enjoy your evening. Bye.
Thank you. Bye-bye.